everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. So we'll be discussing two articles today. Firstly, Cesspool, which is from the Hindu, and a similar article was there named as Hole in Accounts from the Indian Express as well. So we have clubbed both of them for a cumulative discussion. Then secondly, retrospective taxation, the Vodafone case and the Hague court ruling. So this is again from the explained section of the Indian Express. And the most important thing that we'll be discussing in here is as to what do we understand by the term retrospective taxation. Is it even possible or not, or in what cases are they available? Is it available? We'll be studying in this article. And finally, we have the news and flash column wherein we'll be discussing the small and crisp pointer news specifically important for the prelims exam. But before that, let's have a look at the LawSikho courses that we have for you. So we have the Lord of the Courses, which is the Judiciary Test Prep course. So if you are also preparing for Judicial Services exam, then you may definitely enroll yourself for this course. The link to this course is available in the description box below. And also on the landing page of it, you can download for yourself free study material, which is very nicely drafted for all the Judicial Services aspirants. Then we have various other courses like for the CLAT, All India Bar Exam, etc. And also we are very shortly coming up with the UPSC Law Optional course, so you may have a look at that too. The other courses of LawSikho can be viewed at the LawSikho webpage. With this, let's see that what is the multiple choice question for the day. Where is the permanent court of arbitration situated? So you have to tell that where is the location of it. Firstly, Geneva. Second, Hague. Third, Washington, DC, or fourth, Rio de Janeiro. So if you know the answer, you can jot it down in the comment section below. Let's see that what is the descriptive question for the day. What is retrospective taxation? Discuss with latest examples. So firstly, you have to explain the concept of retrospective taxation, the meaning of it, and then secondly, you have to back it up with the latest examples, as one of it we'll be studying even today. The answer must be written within a word limit of 250 to maximum 300 words. With this, let's start the discussion for the very first article for the day, which talks about the cess and transparency. Now, basically, as we know that cess is a kind of tax which is collected by the government, and now recently the Comptroller and Auditor General of India, who actually is a constitutional body, who's a autonomous body and is responsible for auditing the government expenditure and analyzing as to how much and in what way the government has spent in which field. So recently, the CAG has reported that there are many discrepancies and there is a lot of opaqueness in this expenditure or the tax collection by the government, and that is why it needs to be made more transparent. So basically, the recent audit report on the accounts of the Union government by the Comptroller and Auditor General of India pointed out certain lapses in the accounting of revenue from GST compensation cess. So as we already know that there is a huge tussle that is going on between the center and various states regarding the GST compensation, which actually we know that when GST came into India, so the states definitely had to suffer a lot of setback in the tax collection. And on that account, the central government, the union government had promised that they would be paying an amount in the name of GST compensation to the states so that they can compensate with the losses that they had to bear due to the coming up of GST. But till date, it has not been paid, and this is causing a lot of economic crunch in various states. And now even the union government has in a way denied to pay this GST compensation, quoting that it is already facing an economic crunch and various other reasons. But then again, this is one of the reasons that already has increased the tussle between the center and the states. But then again, various other things that came up in the report also have highlighted this more of friction. So the Finance Ministry has retained 40% of the cess collections, which are approximately for rupees 47,000 crore in 2018-19, and this is in violation of the GST Compensation Cess Act 2017, because a major part of this cess collected should have been given to the states in the name of GST Compensation Cess, but it has not been given till date, and that is why this holding of 40% of cess collection, that of this huge amount by the center, stands in violation with the GST Compensation Cess Act 2017. Now let's understand that what are the consequences of retaining the cess. So what would happen, or what actually is happening when the union government is holding upon or sitting upon that cess and it is retaining it very strongly. Firstly, it led to the overestimation of center's revenue and underestimates its fiscal deficit. So basically what happens is that when the center is holding the entire money and not distributing it to the required areas, it gives us a false to say understanding that the center has a huge collection of revenue, which in the true sense is not the thing, because this amount, which currently seems to be really huge because only the union government is holding upon it, but this amount needed to be distributed to various other sources, but that was not done, and that is why it gives an overestimation of the center's revenue and an underestimation of the fiscal deficit. And there now obviously, because the tax collected, if it is seemingly high, which in the true sense is not, so it would actually underestimate the fiscal deficit. Basically, by fiscal deficit we mean the difference that exists between the tax or revenue collected by the government and the money spent by the government. So if it is a huge negative number, then it is considered that the government is not really faring well. And if the fiscal deficit is low in number, then it is considered that it is still fine, because the tax collected and the revenue spent is almost equal. But that currently definitely is not the case. Secondly, the purposes for which the parliament approved such cess was not met, because obviously this cess collection had a huge role in various developmental activities and must have been distributed to the various stakeholders. And this was the very reason why Parliament had approved of such a cess, but that was definitely not done. Then the compensation cess transfers to states were accounted under grant in aid. Now, compensation cess, or the GST compensation cess, was a different thing altogether, and the grant in aid is something really different. But whatever money whatsoever the union has given to the states till date has given in the name of grant in aid, but on the contrary, it should have been given clearly in the name of GST compensation cess only. Secondly, now next, previous instances showing improper account of the GST cess, like the center revolved the year-end integrated GST balance to states in 2017-18, is in contravention with the GST and IGST. And there are various other instances which now the center must be really worrisome about, because this is causing not only a friction in the federalist system of India, but also it is making the states very weak and incapable of acting into the right direction. Now, these are the other instances that have been quoted other than the GST issue. Like, for example, let's take this example. For social welfare fund on customs, no fund for social welfare was created. So basically, the government has been collecting the taxes in particular names, but then when the question comes to distributing that particular amount for that very cause, that has not been happening. Like, for example, for the new 4% health and education cess, which was charged, no fund has been created till date for the health. So this is something that is, seeming like a very opaque thing, and a lot of transparency needs to be created in here. Now, these are the steps that can be taken. Cesses need to be rationalized, like starting with the excise duties on petrol and diesel, and they should be rationalized and collected in a very rationalized manner only. And absolute transparency is needed in the management of cess receipts. So these are the two basic steps that can be taken to ensure that the cess collection does not go in opaque and also does not go in vain, and the taxes collected by the from the side of taxpayers are used in the best of their use. Now with this, let's discuss the second article for the day, which talks about the retrospective taxation. So the Permanent Court of Arbitration, which is situated in Hague, ruled India's retrospective demand of taxes as capital gains and withholding tax imposed on a British telecom company for a 2000 deal was in breach of the guarantee of fair and equitable treatment. So basically here the question comes of we are talking about the retrospective taxation. So firstly, let's understand that what is the retrospective taxation case, or what is the current case that we are discussing. Basically in May 2017, so it was like 13 years back, Vodafone had bought 67% stake in Huchaisan Whampoa for $11 billion. So it is also another company over there, and it had bought worth $11 billion stakes. That was 67% of the all stakes of this company. Then in September 2007, Government of India for the first time demanded rupees 7,990, it must have been in crores, as capital gains and withholding tax from Vodafone. So it claimed that Vodafone should have deducted the tax at source before paying the company of Hutchison Whampoa. But that did not happen, and that is why the government of India asked that now you have to pay it. Now here is the very question of retrospective taxation key. So these were some other instances that took place. You can go through them. Now let's understand that what actually do we mean by retrospective taxation. Basically, it allows a country to tax from a date before the law was passed. So, this is also only something that we call as retrospective. Like, for example, very recently we have gotten this about, the equal right of women in the property as a co-partner. So even that, the Supreme Court has said, has a retrospective effect, and it will be taken in care not from the date where father was is alive or not or something. Just if the daughter was born, she is a co-partner well in there. So, but not all the laws in India and in most of the countries are retrospective in nature. Basically, they're prospective in nature. That, for example, if a law has been promulgated and brought into action on 1st of January 2020, then it would be applicable on the cases or on the situations that would arise after the date of 1st January 2020. This is called a law being prospective in nature. But if a law says that it has though being promulgated on 1st January 2020, still it would be applicable on a date before 1st January 2020. This is called being a retrospective law. So here also it says that retrospective taxation allows a country to tax from a date even before the law was passed. It is used to correct any anomalies in their taxation policies, because many times what happens is that at the time when that particular law was not there and the transaction took place at that time, there must have been or might have occurred some kind of taxation anomaly, and to overcome and to compensate for that, this retrospective taxation is done. Then to clarify the existing laws ends up hurting the company. So basically it helps the government also and even the companies to fall in good proportion and to bring in the right amount of taxation or taxes that ought to be brought. So these are the countries that have retrospectively taxed the companies: India, US, UK, Netherlands, Canada, Belgium, Australia, and Italy. So these should be remembered. Now let's see that what is the Permanent Court of Arbitration's ruling in this case. So India's action was in violation to the 1995 BIT India, that is a bilateral treaty, which we call as India, between India and Netherlands. So it was Article 9. So, and the UN Commission on International Trade, which is the UNCITRAL, according to its Article 3, also it is violated. It says that the constitution of arbitral tribunal shall not be hindered by any controversy with respect to the sufficiency of the notice of arbitration, which shall be finally resolved by the arbitral tribunal. But in this case, the PCA though has said that the action which has been taken by India for the retrospective taxation is in violation to these. Let's see that what does India have to say about it later. Now let's discuss that what is the news in flash. Firstly, first women fighter pilot, flight lieutenant to fly Rafale. So the flight lieutenant Shivangi Singh will become the first woman to fly the Rafale aircraft. As we know that very recently we have brought in a set of Rafale aircrafts from France. This is the company Dassault, which is a French company. So we have recently brought the first set of Rafale. So she was commissioned into the Indian Air Force in 2017 as a part of the second batch of women fighter pilots and currently flying the MiG-21. So the name should be remembered. Secondly, first RRTS train for Delhi Ghaziabad Meerut corridor unveiled. So the government unveiled the first look of India's first regional rapid transit system, RRTS train that we call as. So it will run on the Delhi Ghaziabad Meerut corridor. So this should be remembered, with a top speed of 180 kilometers per hour, thereby reducing the travel time between Delhi and Meerut to just 1 hour. So this was all for today. We hope it was a good and informative session for you all. Stay tuned with LawSikho for such more sessions to come. Thank you.